Today, we're going to talk about term sheets or letters of intent. They basically mean the same thing. It's essentially the beginning step of a business acquisition. You come in and you sign a term sheet or a letter of intent, LOI, and that gets the process started for acquiring that business. So I'm going to go through a sample, and the one today is a stock acquisition because you can do typically the most common is either asset purchase or stock purchase or entity. Either you're buying the whole legal entity like an LLC or a corporation itself, or you're buying its underlying assets. So those are the two main ways that people do business acquisitions. Today, we're going to go over the stock or where you're buying the actual, in this case, a corporation. So I'm going to show you a sample. I'm going to share my screen, and then we will go through, let's see here. And this one is a term sheet, but some people call them a letter of intent. It's basically the same thing. So a term sheet or a letter of intent is a entry stage before you have the full purchase agreement to buy a business. This one is to acquire 100% of the ownership or stock of a corporation. Usually it starts out with just some basics, and essentially most term sheets or letters of intent that you're going to see are non-binding, meaning you can't enforce them. If somebody says, if they sign this and then they back out of the deal, usually you cannot take them to court. However, there usually are carve-outs or certain things that you put in here that are enforceable. So in general, most term sheets are non-binding. However, parts of them may be binding. And so I'll walk through those as I go through the term sheet. So usually there's an introductory paragraph saying who the people are that are buying it, what the company is. And this is just kind of a general, other than these certain, in this one, it says other than confidentiality, exclusivity, expenses, governing law, third party, and non-binding nature. Otherwise, everything else is not binding except for those specific sections. And we'll walk through those. And these are subject to the basically due diligence of the buyer to make sure that everything looks good with what they're buying. So just like when you're buying a house, you do some due diligence, inspections, stuff like that. This is the early stage where they're going to do due diligence and then decide if they want to buy it or not. And usually there's a way out just in case something comes up that they don't like. So essentially a term sheet will outline some of the main terms of the transaction before you get to the full document that goes through like a stock purchase agreement. This is 9 pages. Stock purchase agreement is going to be much more detailed, and it's probably going to be 30 to 70 pages long, depending on the specifics of it. So here we just talk about, okay, who's selling and who's buying, what are they buying? Here it is that they're going to acquire 100% of all of the stock of the corporation in this transaction. The seller could be the actual corporation or the underlying shareholders who are actually selling their current ownership of the company. So if you have somebody who's retiring from a business, they might be the seller because they own 100% of the corporation. What's the purchase price? So you've got maybe an initial amount down, and this sometimes would cover things like if there's a deposit, what happens to the deposit? Here we talk about some amount being due at closing, possibly put into an escrow account, depending on if there's something that has to happen after closing, where you want to set aside $100,000 just in case some expenses come up or whatever the case is. And then also there could be other, and basically I'll go into that in a second here. An agreement, they're going to structure this in the most tax efficient manner possible. When it comes to M&A or purchase transactions, you do have to look at the tax ramifications of how you're structuring it. That can end up being a key part of the transaction. You may not be able to do a stock purchase. You may have to do an asset purchase. After the initial purchase price, there can be some adjustments. Sometimes you have a working capital adjustment. So if you sign your agreement today, you don't close for 90 days, the balance sheet is going to look different today than it will in 90 days. So sometimes you have to adjust for the purchase price for, the working capital or other aspects of the business that might change between now and when you close like 90 days from now. So that's an adjustment to the purchase price, and that's usually covered in a term sheet. Okay, what about an earnout? Is part of the value of the business being paid in an earnout? So an earnout is basically just over time, the buyer's going to pay the seller over time. They're not paying all cash up front or a loan. They're going to do an earnout where the buyer stays in the business, or I'm sorry, the seller stays in the business, typically, and to make sure that the earnout goes through. And as the company earns money, that gets applied towards the purchase price. That's what an earnout usually is. Sometimes you'd have things in here like if there's a certain debt, like a loan that you're applying for, maybe an SBA loan, part of the purchase price might be paid by that loan proceeds. And in that case, you might have a financing condition, which is this section here, that if we can't get our loan, then we can't close. So we would have to be able to walk away from this transaction. So that's what this says. It's saying basically we're going to try to get a loan. You agree to cooperate. If it's the seller, we need bank statements, so that the bank can say, yes, this company is doing well or not. Then the seller needs to provide all that information and cooperate. And if we can't get our loan, then are we able to walk away? Do we owe anything for a deposit? In some cases, there's a rollover of equity. So if there's some members of senior management that may own, let's say 5, 10, 20% of the company, sometimes they'll agree to roll over their equity into, after the transaction so that they continue to have ownership. So usually you cover any of that kind of stuff here. An incentive pool, this just talks about setting aside some stock to give to management out of the deal. So when we close the transaction, we've got a pool of stock still set aside that we can give management to continue to incentivize them to perform for the business. Employment arrangements. So you have to think about the transition period. You're not just buying a business and take over day one and everything's fine. What about the key employees or the seller or anyone that's involved in the business? Do you want to offer, are you bringing in your own team, your own management team, or are you going to offer an employment agreement to the seller or your current CEO, CFO, other management that you have in place? How are you going to handle that in that transition? Same thing with the employment agreements. You might actually set out the actual terms of, okay, the seller is going to stay on as the CEO for 2 years at a $250,000 salary, and he's going to have a written employment agreement. And here are what the specifics are. It's going to include customary non-solicitation and non-compete provisions. These are all things that, the goal of a term sheet is to try to narrow down and see if there's any deal killers. So if the buyer says, hey, I need the seller to stay on for 2 years and keep working so that I can effectively transition into this business, or I need a non-compete that the seller isn't going to go start a competitor down the road, and the seller says, no, I'm not agreeing to any of that, you're finding out now versus when you're trying to negotiate all the documents 3 months from now to close the deal and the deal falls apart. So usually you try to identify deal killers and narrow down your material terms in the term sheet. Due diligence, usually you're going to outline, okay, from the date we sign this agreement, we're going to start due diligence. We're going to start looking over your books and records. You have to grant us access. Maybe there's a restriction that we're not going to interfere with your current work or employees. Sometimes you'll say, okay, well, we want to make sure that you don't tell any of our employees that we're about to sell, because that could cause some issues. So you outline all that stuff and say, this is a confidential purchase. You'll have reasonable access to our books and records, but you cannot talk to our employees unless we have arranged it or something like that. And you usually allow your accountants, lawyers, and all that to have access to all that information, usually put in some type of data room, online, shared folder, whatever it is. In terms of closing the transaction, you want to outline, okay, are there contingencies? We already talked about one. If there's a loan and you can't get the loan to buy the business, you probably need the right to walk away as the buyer. Are there some other conditions before the buyer has to close? Well, due diligence. Number one, that's a big one. Want to make sure that everything looks good, kicking the tires, and that everything looks good, that they still want to move forward. There might need to be approvals from boards of directors, stockholders, whoever's involved on both sides. Signing a more definitive agreement, a stock purchase agreement, employment agreements, all of that. You might need some type of approvals or consents, whether it's for licensing or regulatory, have to get approved for a new buyer or the buyer to take over this company. So it's a change in control of the corporation. And you might need approval if they hold a license. There might be third-party consents on contracts. Contracts might say, somebody new buys this company, I want the right to either terminate my contract with you or not, or for a lease. If the company is leasing their current location, the landlord may have the right to say yes or no to the new person coming in as the new owner. So you have to make sure that you have those approvals before you close. This talks about if there's any kind of restrictive covenants, like a non-compete, non-solicitation, whether those have been agreed to before we close. And also that there's no material adverse changes from the time that we sign this term sheet and the date of closure or signing the purchase agreement. Definitive agreements, that's basically the purchase agreement. Sign the LOI, and then the lawyers start getting putting together stock purchase agreement, employment agreement, bill of sale, assignments, whatever it is, stock power to transfer the stock or an assignment. Any kind of note, maybe there's seller financing. The seller is financing part of it, so there's a seller note. Any of that stuff has to be put together. Usually you'll say, okay, maybe there's a 90-day due diligence period and we want to close within 30 days after that. Within 2 weeks, we're going to send this to our attorneys and they'll start drafting agreements. Or maybe the buyer wants their attorneys to do the agreements, so that's put in here. Exclusivity. So this is a big one that gets negotiated. Once we sign this term sheet, I don't want you going out and looking for a new buyer. So that's pretty common where the buyers say, hey, I want an exclusivity period that while I'm spending money and spending time looking over your business, you're not out trying to get a better deal somewhere else. So maybe it's during due diligence, maybe it's a period of 30 days, some type of exclusivity period where, the buyer has some level of comfort that they're not going to sell to somebody else. But the seller also wants the right to get out of that at some point. They don't want it to drag on forever with a buyer who can't close or, is not really ready to close. Usually you'll talk about expenses. If one side or the other, the most common is both sides, each side pays their own expenses. But in some cases, there can be one side pays legal fees of the other, or some kind of an agreement along that line. Or if there's an escrow company involved or title for real estate, agreement on who pays for all that. Is it split 50-50? Does one side pay? You may also have some type of a break fee, or, basically if one side or the other backs out, then there could be a remedy. Like if you back out after we're done with due diligence as the buyer, then there might be a break fee saying you owe us 50 grand because you did your due diligence, you said you were ready to go, and you just decided to go somewhere else. So you owe us 50 grand. That might be included in somewhere in this sections as well. Usually there's a separate confidentiality or NDA that's already been signed by this point. And so usually we'll reference that this term sheet it's still subject to that confidentiality agreement. If there was not an NDA or confidentiality agreement, then we would want to put one in here. How long does essentially this is an offer. A term sheet or LOI is an offer from one side to the other. Here are the terms we're willing to agree to. Do you accept or not? And you may want to put a time limit on that. Say, okay, you have 7 days to decide and sign this and return it to us. Otherwise, it's, void. It doesn't matter anymore. Okay. And then sometimes you talk about whether you can terminate the agreement after it's been signed. Also, this again refers to the fact that the majority of this is not binding, but confidentiality is binding, exclusivity is binding, expense reimbursements, things that you might need to enforce down the road if something goes wrong. Sometimes you put governing law or other miscellaneous in here saying, okay, this is based on California law or Texas law. So if we have to go to court, what law, whose state law do we have to refer to interpret this contract? You may also say that if there's a dispute, you can go into arbitration, or you can only enforce it in a court in New York or something along those lines. You can get into those specifics too. Then there's generally sometimes some miscellaneous stuff. This one talks about that this can be signed by indifferent counterparts, meaning you don't have to sign the exact same document, same original. Sometimes there's third-party beneficiaries to a contract, and then you sign it. So this is a pretty straightforward stock purchase agreement. There are stock purchase term sheet where you would have a stock purchase agreement drafted after that. So those are some of the basics. Things to look for is, what is a deal killer in this deal? Something that if they don't agree to, then there's no way this can work. And whether you have a broker maybe or an investment banker, they can identify some of those things and hopefully work those out before you get too far into the deal. What are the material terms? Get those agreed upon and in writing so that it'll save you some time, and your attorney will be able to, if this is really well drafted, it'll save you some time and money when you give this to your attorney and they say, okay, yeah, I can do the purchase agreement a lot easier now because I know exactly what we're doing here. So those are the things to look for. We're also going to do one on asset purchases, so I will do that one separately.